My job today is to talk a little bit about enforcement, particularly the type of enforcement that you're going to be seeing at the New York State Labor Department. So there are three types of enforcement that we can look to in New York. First, there's private enforcement, and there has been a whole increase in private enforcement lawsuits. The second method, and Jennifer is here somewhere, Jennifer Brand, Chief of the Labor Bureau. The second method of enforcement is the one that Jennifer now does that I used to do, which is you can go to the Attorney General's office, which has jurisdiction over private businesses. And the enforcement at the Attorney General's office is a very nimble type of enforcement. I always knew it was nimble, but now that I'm at the Labor Department, I understand I'm sort of driving the Titanic and she has a speedboat. So that's the second type of enforcement. The third type is the public entities, the Labor Department and the NYS Labor Department, and that has been an enforcement mechanism which has in the past been not particularly effective and clearly not trusted by workers and by those individuals that work with workers, either unions or community groups. So one of the things I want to talk about is what you're going to see, what you will be seeing at the Labor Department, and how we're changing our enforcement mechanisms to try to deal with the problems that Ned has been talking about, and hopefully as a promo to convince you that, yes, we are a place you can come to again. The first thing that we did this year in January is that the minimum wage increased to $7.15 an hour. Most workers did not know that the minimum wage had increased and that therefore they had a right to higher wages. That was the first thing that we wanted to do, because if you don't know what your rights are, then you're not likely to go out there and enforce them. The second thing that we did was we told our investigators, this sounds stupid, but actually it worked pretty effectively. We told our investigators, your job is to enforce, go out and enforce. And that was a new and refreshing method to them. And just by saying that, just by saying your job is to enforce the law, go out and enforce the law, we will be behind you in enforcing the law. In the first 9 months, without any particular other changes, the Labor Department collected about 20% more than they collected all of last year. So, just telling people they could go do their job, it can actually be effective. So the next thing that we did was that we hired a director of strategic enforcement, because a problem like this is going to require strategic enforcement. Let me contrast that with the method of enforcement that existed when I arrived there, which was complaints came in on a first come, first served basis, they were dealt with. So that means that if an individual came in and said, I was fired last week, I didn't get my last week's wages, and then right after that individual, someone came in and said, I work for, insert the name, chain grocery store, and none of us are getting overtime, the Labor Department would deal with the individual with 1 week wages, and before they would deal with the tens of hundreds of people that may not be getting overtime in the chain store. So we're doing strategic enforcement, we're doing triage, so that the cases where they affect more people, the violations are more egregious, or they're repeaters, will be dealt with first. The bulk of this workforce is an immigrant workforce, documented or undocumented. And recognizing that, that this is a very vulnerable population, we created a Bureau of Immigrant Workers' Rights within the Labor Department, staffed with upstate and downstate advocates. For about 20 minutes, I'd say, I thought I was really innovative and brilliant when I did this, and then someone went back and researched the history of the Labor Department and told me that in 1920 the biggest bureau was the Bureau of Immigrant Rights. So I've only reinvented the wheel. So besides the Bureau of Immigrant Affairs, which is going out and doing outreach and talking to community groups and talking to religious groups and talking to unions and worker groups, we decided to bring the Labor Department to the community. So we created the Labor on Wheels van, which I want to plug also because it goes out a couple of times a week, and it goes to immigrant groups and immigrant communities around the state, parks there. We have people who are bilingual, who are there with information about your rights, and we have tried not just to limit it to labor rights, to New York State wage and hour rights. We have health and safety information. We're going to be putting information about access to driver's licenses on that. So we have a whole range of information. That's sort of how we're getting cases into us and how we're assessing cases. Once we get the cases, I've made a couple of crucial changes that I think will make the Labor Department a more enforcement-friendly place as far as workers are concerned. First of all, as those of you who've dealt with it in the past know, and the past practice was if an individual came in and complained, I'm going to give you an example. Complaint was, I work at X restaurant and I'm a waitress and I don't get paid, I only work for tips. The Labor Department would go in, would investigate that complaint about that worker, assess, let's say, the underpayments, and walk out without trying to figure out whether all the other workers were also similarly underpaid. Now, it's pretty obvious to anyone that if one waitress says, I'm not getting paid, I'm only working for tips, it's likely that the rest of the waiters or waitresses are also only working for tips. But they didn't investigate the whole enterprise. They would only investigate on the basis of actual complaints they had. That's no longer so. If you go into, if someone makes a complaint about a company or an employer, and it's likely that that is a practice that is happening in the whole workplace, we'll investigate the whole workplace. Number two, the statute of limitations is 6 years. In the past, the Labor Department decided to go back 2 years as a matter of convenience, or I don't exactly know what, but anyway. We will go back the full amount of the time of the statute of limitations these days. The Labor Department in the past did not believe that they could impose individual liability. And that would be a huge problem because, especially in these small shops that Annetta has been discussing, you'd have, if there was a large award, the employer would simply go out of business for a little bit and then get a new company name and a new company identity and a new incorporation, and the old entity that we had cited no longer existed, and the Labor Department wouldn't have any ability, therefore, to actually collect the wages that were due. So right now, in appropriate cases, when we think that there is individual liability on behalf of individuals, we'll cite the individuals too, and that becomes an incredibly effective enforcement mechanism, because you'd be surprised how quickly the company pays up when the president's on the hook too. The last thing is, in the past, the Labor Department did not believe that it could assess a 25% penalty for willful violations, which is clearly available to private litigants, and the Attorney General's office always did too. Not surprisingly, the council has changed their mind, and their legal analysis now is that we can and we will be, in willful cases, doing these types of penalties. Now, those are sort of general things about what we're doing. What has that meant in the last few months? And so I want to give a few examples of what we've been doing. First of all, in Flushing, we did a sweep. They did a sweep of Chinese restaurants in Flushing. They went to like every other Chinese restaurant that there was in Flushing. This got the attention of the Flushing business community, and it resulted in a meeting at least as large as this grouping here of business owners in Flushing interested in all of a sudden in coming into compliance with the labor law. I mean, it shows the effectiveness of when you concentrate your resources and you do get the attention of a business community, that the compliance efforts go far beyond your own individual investigations. We've also been doing more proactive investigations. With the help of an unnamed union, we have a large investigation going of an unnamed, because it's not complete, of an unnamed chain of gourmet groceries. And as opposed to the old way of investigation where we would like maybe investigate one store and then a week later go to the other store, or maybe we wouldn't even investigate the stores that we didn't have complaints about. We figured out exactly what stores were owned by the same company. We took 27 investigators from around the state and descended upon all 11 of these stores at once. We had scanners that went in, battery scanners, that we would be able to have half the people scanning the records while we had half the people talking to the workers, so we would be able to show that the records obviously were not reflecting both the true amount of workers and the true amount of hours. So that's the type of thing that we've been doing.